A California tech company just learned the hard way that a single job posting mistake will now cost them triple damages. An Illinois mother was denied time with her premature baby in the NICU, and her employer had no idea they were breaking the law. And across America, business owners are waking up to discover that AI tools they've been using for hiring are now illegal in multiple states. Welcome to 2026, where employment laws have changed so drastically overnight that what was perfectly legal last month could bankrupt your company tomorrow. Good evening. I'm bringing you an urgent alert that every business owner, HR manager, and employer needs to hear right now. As we enter 2026, a tsunami of new employment regulations has just crashed across the United States, and most employers have absolutely no idea what's coming. We're not talking about minor tweaks or small adjustments. We're talking about fundamental shifts in how you can hire, pay, evaluate, and even fire employees. The regulatory environment has been transformed completely. The changes are so dramatic that attorneys across the country are calling this the most significant employment law overhaul in decades. And here's what makes it especially dangerous. Many of these new rules went into effect on January 1st. That means if you haven't updated your policies yet, you may already be in violation. Let me be clear about something. This isn't just a California problem or a New York problem. Yes, those states are leading the charge, but these changes are spreading across America faster than most people realize. Legal experts are calling California, New York, and Illinois the trendsetters, which means even if your state hasn't passed these laws yet, they're probably coming soon. So whether you run a small business in Texas, manage a mid-sized company in Florida, or oversee a large corporation with offices nationwide, what I'm about to share could save your business from devastating legal consequences. Let's break down exactly what's changed and what you need to do about it right now. The leave revolution. When parents need time that you must give. Illinois just passed the NICU Leave Act, effective June 1st, 2026. If your employee has a newborn in neonatal intensive care, you must provide up to 10 days of unpaid, job-protected leave. The leave is unpaid, but you must protect their job and coordinate with other leave entitlements. The administrative complexity is significant, and failure means lawsuits and penalties. New York made history by becoming the first state requiring 20 hours of paid prenatal sick leave, separate from existing sick leave. Employers must now track multiple leave categories without confusion. California is increasing paid leave benefits through higher wage replacement rates under paid family leave and state disability insurance programs, creating more administrative burden for employers. Rhode Island enacted comprehensive amendments to its disability and caregiver insurance programs effective January 1st, 2026, expanding covered family members, adding organ and bone marrow donation as qualifying reasons, and raising benefit thresholds. New York City amended its Earned Safe and Sick Time Act, effective February 22nd, 2026. Employers must provide 32 hours of unpaid safe and sick time immediately upon hire, not after probation, immediately. The amendments also broaden qualifying reasons. The message is clear: minimal leave policies are over. States are rapidly expanding employee entitlements, and non-compliance puts your business at serious risk. The wage wars, when getting pay, wrong costs. Triple now, let's talk about something that should terrify every employer: the new wage enforcement penalties in California. Under SB 261, if you're found liable for unpaid wages, you may now face penalties of up to 3 times the judgment amount, in addition to mandatory attorney's fees. Let me put that in perspective. Say you made a mistake in calculating overtime, and it turns out you owe an employee $5,000 in back wages. Under the old system, you'd pay the $5,000 plus maybe some interest and fees. Under the new system, you could be hit with a $15,000 penalty, plus you have to pay the employee's attorney's fees on top of that. This dramatically increases the incentive for employees to file wage claims, and it dramatically increases the cost of making mistakes with payroll. But that's not even the biggest wage-related change in California. Starting January 1st, 2026, SB 642 has fundamentally redefined what counts as wages for pay equity purposes. It's no longer just base compensation. Now it includes benefits, bonuses, commissions, equity awards, and other forms of non-base compensation. The law also extends pay equity protections to non-binary employees and requires that employers post actual pay ranges, not placeholder ranges, in job postings. You can't just write competitive salary anymore. You need to post the actual range you're willing to pay. Here's the kicker. The statute of limitations for pay equity claims has been extended to 3 years. From the last date, the cause of action occurs. That means employees have a much longer window to come after you for pay discrimination and claims. And let's talk about what's happening with minimum wage across the country. In 2026, 22 states are increasing their minimum wage rates. Several states, including Arizona, Colorado, Hawaii, Maine, Missouri, and Nebraska, will see statewide minimums reach or exceed $15 per hour for the first time. This represents a major shift in compensation standards nationwide. While the federal minimum wage remains at $7.25 per hour, that number is becoming increasingly irrelevant as states and cities set their own higher standards. If you operate in multiple locations across different states, you need to know the minimum wage for each specific jurisdiction, because they're all different and they're all changing. The AI revolution meets reality. Your hiring tools might be illegal. Many companies use artificial intelligence for hiring, performance evaluations, and promotions, but in 2026, using AI in employment has become a legal minefield. Colorado's AI Act, effective June 30th, 2026, is comprehensive. For high-risk AI systems in hiring or evaluations, you must disclose AI usage, assess discriminatory outcomes, implement mitigation measures, document fairness efforts, and conduct regular audits. The compliance burden is massive, especially for small businesses without dedicated legal teams. New York City is expanding reporting obligations and oversight for AI in recruitment under Local Law 144. California is bringing additional requirements around record-keeping and algorithmic accountability. Maryland and Illinois are enhancing protections around automated decision-making and facial recognition. Bottom line, if you're using AI in employment, review those tools immediately and understand compliance requirements in every operating state. Your efficiency tool could become a liability nightmare. The Labor Board is back, and the discrimination landscape shifts. The National Labor Relations Board regained its quorum in December 2025, when the Senate confirmed James Murphy as board chair, Scott Mayer as board member, and Crystal Carey as general counsel. After months of being unable to issue decisions, the NLRB is back at full capacity. Employers should anticipate increased enforcement activity. The EEOC has signaled increased attention to reverse discrimination claims, including cases involving white male employees. This expands focus beyond traditionally protected groups and underscores the need for fair, consistent, well-documented workplace policies. Maintain clear records of all employment decisions and ensure practices are applied uniformly. This is especially critical for organizations using DI programs created under the last administration. Philadelphia introduced groundbreaking protections under its Fair Practices Ordinance. As of November 20th, 2025, discrimination based on menstruation, perimenopause, and menopause is prohibited. Beginning January 1st, 2027, Philadelphia employers must provide reasonable accommodations for employees whose symptoms substantially interfere with job functions. This is significant because these aren't recognized as protected classes under Pennsylvania or federal law. While Rhode Island passed similar legislation for menopause in June 2025, Philadelphia is the first major city extending protections to all three specifically. The marijuana. Question: a schedule change is coming. A recent executive order has directed the Department of Justice to complete the rulemaking process to reschedule marijuana from Schedule 1 to Schedule 3 controlled substance. Since 1970, marijuana has been classified as Schedule 1, meaning no currently accepted medical use and high potential for abuse. Schedule 3 drugs are viewed as having moderate to low potential for dependence. Until the DOJ officially makes this change, your obligations regarding drug testing and workplace policies remain unchanged. But you need to prepare for what's coming. Here's why this matters. Employees may start seeking marijuana use as a reasonable accommodation under the Americans with Disabilities Act. Courts have previously rejected such claims at the federal level, but state or local laws may apply, adding complexity to compliance. If you're conducting drug testing, especially if you're subject to Department of Transportation regulations, continue standard practices for now. But start reviewing your policies because once rescheduling occurs, you may face questions about enforcement of substance abuse policies and accommodation requests. The California cases that could change everything. Several California Supreme Court cases are pending that could have massive implications for employers nationwide. Remember, California often sets trends that other states follow. First, there's Fuentes versus Empire Nissan. This case examines whether arbitration agreements required as a condition of employment can be unenforceable due to unconscionability. If you're using mandatory arbitration policies, you should be reviewing your agreement language and consent procedures right now to evaluate enforceability. Second, there's Hearn versus Pacific Gas and Electric. The court will clarify whether a terminated employee can bring a defamation claim against a former employer if alleged statements contributed to their termination. This decision could affect risk exposure for employer communications regarding employee performance or termination. Third, and perhaps most significant for California employers, is Leaper versus Shipped. This case addresses whether all PAGA actions must include both individual and non-individual claims, or if a plaintiff can bring a non-individual headless PAGA action alone. For those unfamiliar, PAGA is the Private Attorneys General Act, and it has traditionally required the named plaintiff to have personally suffered at least one labor code violation. If the court permits purely representative claims without an accompanying individual violation, the threshold for filing PAGA actions would be substantially lowered. That would open the floodgates for employment litigation in California. What you need to do right now, schedule a comprehensive review of all employment policies with an employment law attorney. Don't wait. Don't assume last year's policies are still compliant. If you operate in multiple states, you need state-specific compliance checks. What works in Texas might be illegal in California or New York. If you're using AI tools in hiring or performance evaluation, audit them immediately. Understand how they work, document their use, and ensure you're meeting disclosure requirements. Update your leave policies to account for new requirements in your jurisdiction. Train managers on proper handling of requests. Review pay practices carefully. Calculate wages correctly. Post accurate pay ranges where required, and maintain detailed documentation of all pay decisions. If you use arbitration agreements, have them reviewed. In light of pending California cases, you may need to revise language or procedures. The stakes have never been higher. A single policy mistake, one misclassified employee, or one improperly posted job listing can result in triple damages and regulatory investigations. Employers who will thrive are those who take compliance seriously, invest in proper policies and training, and stay ahead, rather than reacting after penalties. Stay informed, stay compliant, and protect your business. The cost of prevention is always less than litigation. That's our report for tonight. I'm urging every business owner watching to take action immediately. The laws have changed, enforcement is ramping up, and penalties are severe. Don't become another cautionary tale. Get your house in order now. Review your policies with qualified legal counsel who understands the specific requirements in your state and industry. Document everything meticulously, because in this new era, your paperwork is your protection. The employers who take swift action today will be the ones still standing tomorrow.